Commissioners, that would be item 9A. It's a recommendation to adopt an ordinance establishing short-term rental registration requirements for owners of short-term vacation rentals 6 months or less in unincorporated Collier County at a rate of $50 for a one-time non-transferable fee. Mr. James French will present.
Good afternoon, Commissioners. For the record, Jamie French with Growth Management. I'm happy to provide you with a presentation. This was just brought to you at your last meeting where you approved the advertisement, and this is the adoption hearing. So happy to go through this. I know that the Naples Area Board of Realtors, who we have met with a number of times, is here as well, or just happy to go into questions.
I don't see any questions. What's the pleasure of the board? Shall we hear from the speakers?
Yes.
I think so.
I'd like to hear from our speakers, and then we can deliberate. And I don't need to have another presentation.
No.
I think we've reviewed this ad nauseum personally, so.
Okay.
It's 2019, sir.
Yes, sir. Lots of testimony. So let's,
Madam Chair, we have 6 registered speakers. I think maybe a couple of them might have had to leave due to the hour. Danielle Hudson is our first speaker. She's been seated additional time from Martin Mannion. Is he in the room?
Make sure he's in the room.
She has a total of 6 minutes, and she will be followed by Brad Estes.
Good afternoon, Commissioners. My name is Danielle Hudson. I am the Vice President of Public Policy at the Naples Area Board of Realtors. As previously mentioned, our board has been engaged with the county on the Collier County Rental Registration Ordinance since at least 2019. And we are amenable to the intent and spirit of the ordinance you have before you today, which is to collect current and accurate information regarding short-term vacation rental properties and to encourage the appropriate management of these properties. That being said, while this ordinance is clearer than earlier drafts that we have reviewed, the board does have some specific suggestions that you hope you'll consider. So first, we believe that the definition of short-term vacation rental in the draft ordinance needs to be expanded to clarify the homes that will be required to register under the new ordinance. As it stands, the current ordinance language references State Statute 21203, which gives the county tax collector the authority to collect taxes on transient rentals for 6 months or less. However, not all transient rentals are required by the state to register with DBPR as required in the Collier Registration Ordinance under Section 3.1. To ensure that the ordinance is clear for practitioners and homeowners, and to specify which homes will be required to register, we believe it would be best to add a reference to State Statute 509-2421C, which defines transient public lodging as homes that are rented to guests for more than 3 times in a calendar year, for periods of less than 30 days or 1 calendar month. We believe that this is important to include to clear up any confusion if this ordinance is enacted, being that DBPR does have licensure exclusions pertaining to homeowners that rent their homes for longer periods, such as 6 months, and that do not consistently advertise as transient public lodging. We just want to make it very clear if this is enacted, who needs to register, so that as they go through that process, there are no questions. Next, we would like to point out a few pieces of information that we hope will be food for thought for you all. There is some concern among some practitioners that have spoken at our board that this registration ordinance may be duplicitous in terms of existing state and county tax registration processes. So as it stands, homeowners are required to register with DBPR and with the county tax collector via the business tax receipt process, which is extensive and collects an excessive amount of information. If this ordinance should pass, in fact, it will be the tax collector that sends notification to homeowners that a new registration process is required, indicating that contact information and who owns the property is listed in county records. Further, a review of existing code enforcement complaint data reveals that a process already exists for neighbors and interested parties to refer non-DBPR licensed individuals to code enforcement. And there, I will just stop and mention that we, year over year, request FOIA data to take a look at the complaints that are coming through the county. Over the last 3 years, if you remove duplicates, there have been a total of 65 complaints related to short-term vacation rentals. Of those, only 3 have had case pending, so we're looking at 1%, really, of even the complaints that are going to case. I bring that up only as a data point for you to show you the exposure of what we're seeing in code enforcement in terms of complaints related to short-term vacation rentals. And of the homes that have complaints related to non-DBPR licensed individuals that are going through the existing code enforcement process, 15 of the 16 were brought through voluntary compliance. So there is an existing process, and one of the suggestions that we have, if we want to move forward with a registration in order to get designated responsible parties, I guess in a database, would be to, instead of maybe having a Collier registration number being required, that we ask and mandate that they list their DBPR license number in their advertising. It's something that already exists for people that are following the law. It's something that they would already have, and it would also free up growth management from having to put in a new registration process by which they have to release registration certificates. If that is not the will of the board, then we may suggest that we put parameters in terms of turnaround time of when homeowners should expect to see their Collier registration, if that is the direction that you choose. And that is in line with some of the state bills that we have that are going through, namely SB 512, which is requiring a 60-day turnaround time for local registration certificates. So I mentioned that also because there is current legislation going through at the state level that specifically pertains to local registration and advertising. And so it may make sense if you choose not to simply list the DBPR license number and you choose to do a Collier registration number, that we have that turnaround time baked in to this. Finally, we really just want to thank Growth Management. This really has been a process. They've been very hospitable and open to our questions, of which, we've had many over the past couple of years. Jamie French and his team has been very open to answering our questions and taking our comments, and we hope to continue this dialogue moving forward. Thank you.
Thank you.
Your next speaker is Brad Estes. He'll be followed by Laura Puckett.
Good afternoon. Brad Estes with the Poinciana Civic Association. We wholeheartedly endorse this creation of the requirement for short-term rental registration, and this is short-term rental registration, not just vacation rental registration. And short-term rental registration is an issue with us as well as vacation rental registration, so please consider that. It's not just vacation rental. And we also are, especially happy to hear or glad to hear that there'll be a designation of a responsible party. Responsible party. Who do we contact as an association? Because as in our case, we often contact the residents or the owner, property owner more likely, as a courtesy before we complain to code enforcement. But who do we contact? Let me put a we struggle with getting in contact with ownership. This is the copy of our letters to owners over the last 4 years, asking them to help us with compliance, whether it be trash parking, late night parties, whatever the issue is. The associations need access too. The associations can assist. We don't have to go to code enforcement, and we attempt to use code enforcement as the last measure, but we don't have the information. And of that, I can count on probably one hand, and there's probably 300 to 400 there, probably 400 there, letters that went to property owners, cut on one hand, where we have heard from homeowners. So, but we actually, though, and I have to add, they have been fairly cooperative in responding to our concerns. So I would just like to thank Commissioner Solis, because I think, and as others as well, for following this up and has been considering this. It's a situation that is not just, in our case, distracting and a threat to our community character, but there are communities that have been actually had very serious consequences from this. How you approach it, I don't know, but we think information is the first thing. Who owns it, and who's going to be responsible, and who's going to be immediately responsible, if I could ask, if I might add that, immediately responsible. Thank you.
Thank you.
Your next speaker is Laura Puckett. She will be followed by Christian Jasinski. I think they have left. Let me move on. Maurice Cossart. They have all left, ma'am.
So, Mr. French, we heard, we heard testimony from the Board of Realtors. Are you in agreement with the modifications they suggested?
Commissioners, excuse me, again, Jamie French for the record. Just for some record clarification, with regards to the duplication of information, the information that the tax collector has when you register a property as a vacation rental or short-term rental, that is not readily available to us. So it's not duplicative to us. It's unique. And with regards to having any type of unique identifier, much like it, and I would only ask each one of you on this dais, when you've ever reached out to me before, whether it's a land use petition or whether it's a building permit or a code enforcement complaint, you've got a unique identifier beyond the address. That is issued immediately. So as soon as that is applied for, you receive a unique identifier. It is not months. And our process that we're working on now, and the reason why we're asking for a January go-live date is because it will be available online. It is simply show us your DPR registration, show us that you're properly filed with the tax collector. Here's your license. Give us a designated point of contact. We're done. There's not a whole lot of review other than the zoning piece. And the reason why we bring in the zoning piece is that we want to make sure that we don't have a cube farm standing up in a warehouse building that now all of a sudden you've got a hostel or you've got a bed and breakfast that really should be an industrial park warehouse. And so that's where we tie into zoning review, and that's already standing regulation that exists. So we're not impeding or impairing any of the state process, and it will be an immediate look at that property over the counter. So, ma'am, we process about 6,000 permits a month. So to say that we've got 10,000 or 14,000 rentals out there, okay, give me a few weeks, I can get to them. Not that big of a deal, and we'll work with it. Now, as far as the code enforcement pieces, and look, as Danny said, they have been really good, much like the county attorney's office and the community and the sheriff's office. Really, really good partnerships there amongst all of us to work on something good for the community. But with the code enforcement piece, we register those as a short-term rental, but we close out the case because we don't regulate short-term rentals. They typically lead to property maintenance, noise, junk cars, broken windows, property maintenance type issues. So they could be opened up as a rental or a short-term rental, but we have no authority there because we don't regulate those, and we're still not going to. Again, this is a registration process, but we do agree with NABOR that 509 does give good definition, and 509 is mentioned in this ordinance. So if it's anything that 509 exempts, if that's the language, staff would agree with that.
Okay. Commissioner McDaniel, Commissioner Solis, and Commissioner Ocastro.
You answered my question. If 509 is mentioned in that ordinance, and you're okay with adding that or having that as part of that definition, that I think that takes care of the one thing that she said. And then the other thing with regard to the DBPR number that a short-term vacation rental is supposed to already get, could we add a reference to that? Is that a part of this application process for that registration?
Yes, sir, it'll be in there. It'll all be there.
Commissioner Solis.
I was just going to mention the reference to 509-242-1C or whatever the exemptions are. I mean, I think we could just, and the county attorney and I spoke about it yesterday, I think, just to say, short and sweet, this is applicable to all short-term rentals not exempted by the statute, whatever, just so it's in there, because I think it wasn't only Neighbor that brought this up, the Florida Rental Property Association. Did I say that right? Are they here?
Apartment Association.
Apartment Association.
Or John Christopher or
Yeah,
something.
made the same request, and I think they were right. I mean, you'd have to go and look up 509. So if we could just make that clear in the statute, what's included and what's exempt, then I think that'd be easier. The county attorney is
I know.
holding
you
his
look
head over there.
Perplexed.
No, I mean, we spent 3 years on this ordinance, and I know Mr. French has spent an enormous amount of time with the industry to get this particular definition. And every time we get to this definition, the goalpost changes, and we want a new definition. And I'm happy to make adjustments, but if you're exempt by the statute, you're exempt. That's the end. That's the end of it. And the definition, I think, is as clear as we could possibly make it over the 3 years.
But I think the issue is that somebody that's a homeowner that just looked at this, that they may not even realize that somehow they're exempt, because they don't even know there's an exemption to 509, because they have to then go to 509 and see what 509 says. So
Well, 509 doesn't really do what they say it does. The core of this ordinance is that we need a contact person when somebody's partying at 2 a.m. That is the heart and the soul of this ordinance. It really doesn't do anything else. We know who the apartment people are. They're easy to find. There's apartment managers.
right, but I mean, they don't have to register under this because
If
they're
you want to-
exempt from
If you want to say
509.
apartments do not have to register, that's fine.
Yeah, whatever's exempt by 509.
But 509 doesn't exempt them. What I'm saying is, 509 doesn't exempt them, but it doesn't matter because we know who they are. The purpose of this ordinance is to make sure that we know who you are. And right now, we've got countless outside investors buying properties all over Collier County, renting them out through Airbnb. We have no idea who the contact people are.
So, Commissioner, if you wouldn't mind, what I've provided you is, this is the DPBR's guide, kind of their fast facts.
Right.
To who needs to register and who doesn't, and we hand this out, and we will include this within our letter, so it's just a recreation of what the state is already doing. But if you could jump just to this PowerPoint slide, you've got a definition that's identified within 509 that talks about non-transient apartments, which would be exempt, and then you get your transient apartments. 509 clearly identifies what those are by definition, by percentage of usage, on how much of those units would actually be considered short-term. So it's short-term, and we understand it from the apartment's point of view, because there may be companies that come along and may only rent for 2 or 3 months while they're placing an employee that they're bringing into a market, or perhaps it's a prospective buy where they're just trying to finish a home. So we recognize that, but the statute does clearly call out 509, or within 509, it does say what's exempt and what doesn't. So if we need to strengthen that language within our correspondence or within this handout, we'll certainly do that. Because if we're not going to try to enforce something that is exempt by law.
Yeah, I would suggest you allow staff to implement this ordinance, and if for some reason there are any kinks along the way, we'll come back and make the change. Happy to, but I think this language works. I really do. And again, this has been 3 years we've been going back and forth with the industry on it, and we've never gotten consensus on anything.
Okay, so looking at short-term vacation rental, it says, short-term vacation rental means the rental of any habitable space, including a room, apartment, living quarters, in any residential building, including but not limited to condos, multifamily, for a term of, okay. So, and maybe I misunderstood, so we want just commercial rental apartment owners to have to register as well, or we don't?
If they are considered transient apartments, to where you've only got maybe, let's say you've got 10 units, and only 3 of them live there longer than 6 months, the rest of them are short-term rentals, sir. If they're renting them a month at a time or a couple months at a time, it would fit that definition under 509. And the state clearly defines that. So this isn't anything that we're defining at a local level. So what Nabor said, what Danny has said is absolutely correct. So if we need to strengthen the language and the message that 509 is the overall deciding document,
Right.
by all means, absolutely.
That's all I'm suggesting, is just put a reference into 509, 242, whatever it is, that makes those distinctions as to what's exempt and what's not.
But that's the last line of the definition.
Can we put that up?
It just,
Well, we can add apartments if you want, but that's, if we can put it up.
okay, well, 50, it just says 50, I'm just saying, can we,
We don't have that definition here.
Not included.
It's not in our packet,
I'm
so.
suggesting that instead of it just saying 509, that we actually cite, 509 is a
It's a big
whole
statute.
statute.
It was actually referenced 509.2421C.
There it is.
I don't understand what the downside to,
I thought that's what we were actually doing when I asked if it was, I didn't realize it was the entire statute 509, but if we just add the language of .2421C,
We'll work with the county attorney's office, sir. Staff has no concerns, and we'll make it right.
Commissioner?
More specific, you've answered most of my questions. 2 things that I did hear from Ms. Hudson and the second speaker as well. She was saying the DBPR number would, she was suggesting it be the number and not some special county number. I didn't know if I heard you answer that you agreed or disagreed with that. Do we need the special county number? Is it sort of redundant?
So the
Did I miss
number
that?
is a unique county number. That is not a shared database. So if someone were to call in and we were to do an investigation, that's it's where the sheriff's office or code enforcement or EMS or fire, they're going to have access to this database, that they would be able to put in that county number through our CityView software, and it's there. I would not be able to cross-reference that unless you went into that individual property, and you would have to look for it within the registration. We don't share data or the database with the state of Florida. That is not available to us. So that's where I talked about the duplicity. That duplicity does not exist between the agencies. I wish it did, but it is not available to us either other than perhaps in flat file or whatever the actual applicant would offer us.
So at 1 o'clock in the morning, it's nice to have.
We're going to generate that number, and what I heard, and I may stand corrected, was the amount of time it takes to get that number
You
issued.
said it generates immediately.
It's immediate, and it is unique.
The second thing I had was the second speaker took exception to the term vacation, that it's really all rentals. What is your comment to that?
I totally appreciate Mr. Estes. I'm glad that he didn't say anything bad about growth management. So, no, listen, it's, the state defines it. The state will define what that is. And again, we've worked very close with Mr. Estes and Point Santa as well as a number of these communities, so we're appreciative of their input, but we're really relying on state statute.
Got it. Thank you.
Okay. Are we all satisfied here? Do I hear a motion? Commissioner McDaniel?
I'll make a motion for approval with, and I think if it's okay, we'll add the specifics with regard to 509 in there that was mentioned for the definition purposes.
We'll add the language. I will email each of you a copy of it. If for some reason you object to it, we'll bring it back.
Perfect. I'll make,
Otherwise, we'll just implement it.
Do I hear a second?
Second?
Motion on the floor in a second. All those in favor say aye. Aye. Those opposed, like sign. Thank you. And thank you very much for your patience.
And cooperation.
Yeah.
It's been mentioned multiple times in the industry, the folks, there was a whole bunch of people running for the cliff to jump off that didn't. And you folks were really assistful in communicating the message.
Very quickly, just thank you to Jeff. He's been not only is he a good colleague, but he's been very, very helpful through this process, so we're appreciative of his office.